Good morning, everyone, and welcome to today's APM webinar, Legal Project Management. And I'm delighted that Peter Dombkins from Newlaw from PwC is joining us. I'm Robert Allen, APM Branches Manager, and I'll be your host today. It's great to see so many people online today. I personally would like to thank all the volunteers from the APM branches and SIGs for all their hard work in arranging these webinars. So, Peter is a recognised national expert in legal transformation, legal technology and legal project management. So Peter, over to you.
Thank you very much, Robert, for the very warm and kind introduction. And hello everyone online from Australia. Good evening from here. A little bit about myself and then we'll get into all things legal project management. I'm also an adjunct associate professor with the University of New South Wales Faculty of Law, specialising in legal project management and legal transformation. And before my role currently at PwC, I formerly headed up the legal project management and legal transformation team at a top-tier national Australian law firm, Gilbert and Tobin. I am a lawyer myself, originally in projects, but I spent the majority of my career in legal operations and also in project management and organisational change more broadly. So I'm a member of the CHPP. I'm also Certified Practicing Project Director with the Australian Institute of Project Management, where I'm also a National Project Management Assessor. So enough about me. Let's get into what on earth is legal project management. And I just thought I'd start off with this little slide, a recent piece of analysis put together by the World Economic Forum, talking about the relevance of roles, both current and projected. Was only talking from 2018 to 2022, so we're already halfway through this journey. And as you'll be able to see, general managers and operational managers definitely seen as stable and relevant roles, which is great news for everyone on this call. You may, skimming through that, you might see other roles which are certainly part of the Prince 2 or PMBOK frameworks, things like risk management and HR roles, things which are commonplace and well known to project managers. But then on the other hand, we have lawyers seen apparently as a redundant role, sharing company with telemarketers and door-to-door salespeople. So there's clearly, we're very curious about the World Economic Forum's position on this and why they saw lawyers suddenly being a somewhat more redundant role. And we'll get into that in terms of how do we make the profession a little bit more than the legal profession, arguably the world's second oldest profession, arguably also not going anywhere soon, but how do we make it a little more relevant to the type of environment that today's clients find themselves in? And that's really where things like legal project management help. Thought I'd also just start with a bit of an introduction to what Newlaw is, being that that's the department or that I currently work with at PwC. Newlaw, we specialise in legal transformation, so helping law firms, in-house legal teams, and even courts adapt, transform. You can see a couple of key areas that we look at, including obviously legal operations transformation, implementing various forms of legal technology, legal workflow automation, document automation, and a large focus on various managed services, both legal and back office support managed services. There's also a very significant and established Newlaw capability in the UK itself. And this just gives you a bit of a sense about the types of services that a Newlaw team would offer, everything ranging from outsourcing, workflow automation, workforce structuring and team structuring, strategic planning, a degree of target operating model forecasting and the like. So enough of the infomercial about who we are, and let's get into LPM. I really like starting this session, and I've thought, it must be approaching about 10,000 lawyers now, legal project management, and I really like starting with a slide like this. It really it's a tale of two professions, and it indicates the mindset of lawyers. On the left, we have a certain lithograph from medicine in the top left-hand corner there. It's a lithograph from medicine in the 1700s, and as you can see, it's somewhat terrifying. We have an individual's head being put into a kiln and dreams come out, because obviously that's how science works. And don't ask me what's happening in the back left-hand corner there. It's horrific. But that's medicine back then. And we fast forward 300 years, that's medicine now is very different. You can spot significant differences both in team structuring, use of technology, very different experiences for all people involved, both the doctors and the patient, very different potential outcomes for the patient. Now, if we compare that to on the right-hand side at the legal profession, and these are two etchings actually from quite famous cases, the Zenger case and the Canning case in the UK and the US respectively from the early 1700s. And then we compare it to, well, choose your favorite court. This particular image is taken from the Supreme Court of Victoria, but I assure you that the pictures from various UK courts would be similar. We have the same bewigged individuals, the same oakened panels, in fact, oftentimes in this very same buildings. And being common law, oftentimes arguably the same principles of common law and arguably possibly the same statutes on the books. So there's effectively 300 odd years of professional inertia. Now, what impact does that have on a profession? What impact does that have on the mindset of the professionals in that profession? Well, it manifests in a variety of inefficient behaviours. We start off with very much a fixed mindset. There's principles like stare decisis, which is a legal principle that courts are bound by previous courts' decisions. That's an established legal principle, and I think it plays over into some of how they believe things should be done. We do have a preference to do things the way we did them before, and we can definitely spend, as knowledge workers, spend a significant amount of time doing tasks in a repetitive fashion when there could be a more effective and efficient way to do it, such for example as through automation or outsourcing, but we just prefer to do it the old way. A good example is when we look for information. As knowledge workers, we spend about, on average, 30% of our time looking for information, in particular that magical co-location, or the holy trinity of tasks, emails, and documents. And if they can't find it, of course, then they spend a good amount of time looking for it and can't find what they're after. So the next best solution is to just go and recreate it, which is piling inefficiency upon inefficiency. Not if they spent time looking for it, couldn't find it, but now they've recreated it. And part and parcel of that is poor communication, not actually reaching out to colleagues, very much operating in siloed mentalities. A lot of law firms will, the old eat what you kill, sharing is not caring, and they tend to keep to their own. In fact, in Australia, and I believe that this in Canada, and I wouldn't be surprised if this was the same for the UK, the equivalent of the Ombudsman for the legal profession provides an annual report baselining complaints against the legal profession. And when we look at it in Australia, New South Wales and Victoria, which are the two largest jurisdictions of lawyers here, the leading causes of complaint are often negligence, and right up there, poor communication. They vie with each other for taking top place, ignominious top place as the leading cause of complaint. Other impacts of this mindset, we can tend to make ready, fire, aim approaches. So we quickly see a problem and then gut feel jump towards a solution. Lawyers are in fact trained to do that in law school. Through the various tertiary processes, we'll be given an unseen problem and we have to quickly diagnose it and come up with a solution. As we'll get into, that's not exactly aligned with best practices for pausing and planning. Other studies, particularly looking at our US colleagues, but again, no reason the results wouldn't be global in this respect. The profession is pessimistic. In fact, pessimistic law students have been shown to outperform optimistic law students at law school. And for those that are actually lawyers, that's what they say, past, what's that say about them? Highly skeptical. In fact, another survey of about 1,000 lawyers showed that skepticism and narcissism were the two leading personality traits of lawyers. And low trust. Why trust other people when you can do it yourself? Our last point is that lawyers tend to have difficulty quantifying the value that they actually are delivering. usually because there's a complete lack or dearth of structured data about what they're doing. Lawyers tend to not, in many cases, use structured processes. It's kind of a lead into what we're talking about with legal project management, and very rarely are using structured project management method tools or systems in what we'd be referring to as practice management or matter management systems, or if they do, they're very rudimentary at best. So because of that, they oftentimes lack the data to show beyond just pure billing data the value that they've delivered or received. So these are some of the problems of some of the attributes of the profession. For those that are looking to enter the profession as legal project managers or have the managing projects with lawyers on them, know your enemy. Know what this is the mindset, and it's obviously these are stereotypes and generalizations, but they do hold to be broadly true. Now, the change the profession shall and change the profession must. There are a variety of reports out there, and I'll see I believe this presentation should be available as a PDF distributed to people. I'll check with Rob and if that's the case, but these particular reports are hyperlinked if you do get a copy of this presentation. There's a variety of reports put out by law societies around Australia and globally. I've got examples here from across Australia, Singapore, the UK, and the US, which do start to talk about how the profession is starting to evolve in response to COVID, in response to broader changes and the gradual managerialization of the profession, the creep of managerial approaches into partnerships and professional structures, which is a process which has been going on since the 60s, but was really accelerated post GFC, and then a second wave of acceleration with COVID, which is this particular slide. There's been a number of leading commentators, including, as you'll see there, Mark Cohen, quite well-known legal futurist, often published in Forbes magazine. And I've got a hyperlink to his particular Forbes article, pointing out that there's going to be, you've probably heard this in many different professions, and legal is no exception, that there will be no return to the old way of doing things, that there will certainly be a new normal in terms of how the legal industry operates. We've seen most obvious example is with the courts, who have been required to courts which have otherwise, as by way of a little bit of a story, I was delivering a keynote speech at the national conference for Australian Institute of Project Management a couple of years ago at their national conference, and preceding me was a very eminent and esteemed judge, senior state judge, who were speaking about the transformation that the courts in his state had undertaken, and with pride boasted that they had finally gotten rid of the need to wear wigs. This was seen as a significant development and transformation. Now, you take that as a boast, and now you look at what's changed in the past 4 to 5 months. Rapid digitization. We've got judges learning how to use Zoom and Google Hangouts for the first time, and WebEx, which has caused no degree of consternation for barristers and lawyers all over the place. But we've seen even the bulwark of or the bastion against transformation sometimes in forms of courts and barristers, even they are moving with the times. So certainly COVID is seeing a dramatic transformation in how legal services are delivered. I've got some statistics here recently put out by the survey by PwC, where they were surveying CFOs on a regular month-to-month increment to see what their priorities were and how they thought that was going to impact the workplace. But certainly areas like remote work are now significantly starting to change how legal work's done, and in particular start to address some of those earlier concerns I mentioned, like, for example, low trust. But I wanted to spend time a little bit on this slide, which I really think encapsulates some of the new thinking of the future lawyer. This is the T-shaped lawyer. The concept of the T-shaped professional, if you haven't come across it, was developed by the McKinsey back in the 80s. It's been around for some time, but it was popularized for legal in about 2014 by an individual, the name is Smathers. If you haven't seen this before, the concept's quite simple and self-explanatory. You will have a deep area of expertise in one area, in this case, legal expertise, but across the horizontal part, the T there, there's an awareness of a variety of different other disciplines, starting off with legal project management, but other areas like continuous improvement, change management, product development, business development, leadership, risk, and technology. These are areas which we want lawyers to be increasingly aware of. Do we expect them to be an expert in them? No. Do I want them to be able to have at least a reasonable conversation with an expert in one of these areas and possibly know how they could engage and benefit from their services? Yes. Do we? So there's a bit of an argument, a common argument around that goes around the legal profession now about, do we need lawyers to code and teaching lawyers how to become coders themselves? I'm firmly of the camp that we don't need lawyers necessarily to code. What we need lawyers to be aware of are the problems that coding could solve, and to be able to articulate them and then talk sensibly with a project manager or an app developer so that then they could go off and develop the solution. So that's when you see, and there's two parts of this, because we want lawyers themselves to be aware of legal project management and be able to interface with legal project management or LPM professionals such as myself, and there's a small army of us out there. But equally so, particularly in form of LPM, we do want them to be able to adapt and apply some of those skills themselves. Maybe not for the most complex matters where they could actually do with some professional support, but for the everyday matters, we actually do want them to start to apply some of these principles. Which gets onto this slide. Usually at this point in time, I have a surprise if I'm teaching lawyers and introducing them to project management principles. Surprise is that, by the way, you already all are project managers. You just unfortunately were never taught how to be one. By definition, every legal matter is a project. And by legal matter, I mean a brief. Someone asks a lawyer for advice. Even using the standard definitions, for example, I've got one from Pinbock there, but a standard definition of a project, it has a start point and end point and a deliverable. And so that stands to reason that if the lawyers that are working on these projects are themselves project managers and project team members. Now, with having been a lawyer myself, the problem is that in law school, we're only taught black letter law. There'll be a defined group of subject areas, ranging from criminal law to administrative law and real property and intellectual property and the like. And they're the mandatory subjects, along with jurisprudence and ethics. And they're great. But there's no mandatory subjects such as legal project management 101 or business acumen 101. A lot of these applied skills for how to deliver law as a service, not just be aware of the law itself, but how to actually apply it and deliver it in the context of a project, that's most often actually learnt on the job as part of a vocation-based profession, which isn't great, and is certainly in the courses that I'm now teaching, and we're starting to see a change in legal education itself, particularly through elective courses and supplementary courses, where we're starting to introduce these concepts right at the beginning of the supply chain, still still in the education part of an early career professional life or career, so they can actually get onboarded with some of these principles from day one. Now, when I'm explaining to lawyers why, what legal project management is, and I know this is a APM session, so you'll forgive me for the Pinbock reference, but nonetheless, it's an easy one to use. What legal project management isn't, it isn't putting a big L in front of this, right? There are 49 odd processes and plans in there. And an innumerable number of subplans and specific processes, which are fantastic in a normal project context. But as I described to lawyers, normally, when we have a project, we'll have dedicated resources to implement most of these plans, like program directors and risk officers, and we'll have people in schedulers, people who do this, who are in charge of updating and maintaining various project plans. It works quite well. Obviously, it has a degree of administrative overhead associated with it, and that there is the issue in law firms and in private practice. So in law firms and in in-house legal departments, they don't have usually the additional resource of an on-demand project manager to help them do legal work. They have to plan and scope and plan and deliver and report upon the legal work all at the same time. So they don't have those additional resources. In fact, the only people that don't have to worry about delivering law as a service really are judges. But everyone else should be worried about things like scope management, and managing risks and identifying them, and what the tracking various deliverables. And those obligations will fall upon the lawyers. Now, lawyers are generally highly overutilized. They'll be they're very diligent creatures. They oftentimes read everything, and the business takes advantage of that oftentimes, and will make, particularly in an in-house environment, they'll be forwarding lots of different documentation to lawyers. They're busy people. Just ask them. And if I went to them and said, on top of your very busy day, could you please take out the time to spend an additional 10, 20% of your time, 30% of your time doing project management as a compliance function, filling in all these detailed project plans, just to make me as the project manager happy. Would you do that? And I'm sure they'll have some choice and possibly impolite words to say to me were I to dare make that suggestion. So when we're teaching project management to lawyers, it's very much an adaptation of traditional project management for them. We take some of the parts of it, contextualize it, really boil it down to some key principles, and leave it at that. So one of the first ones that we'll show them, and obviously most everyone on this session, I'm sure, will be very familiar with the triple constraint. Most lawyers, unbelievably, when I'm teaching them, have never come across the triple constraint before. And that's why oftentimes we'll have actually it's good, fast, cheap, and they may well have heard of that. And are they doing this as a possibly default? Are they doing it when they particularly say in an in-house environment, a client or the business comes and asks them to do something at the last minute, but won't give them any more budget? There's going to have to be some give and take there. They usually find this particular model then extremely useful to help conceptualize, okay, so there's effectively a consequence of actions. If I have someone that's asked me to do something which is impossible, so on the right-hand side, la la land, it's good, it's fast, and it's cheap, how can they have a structured conversation to help identify what the trade-offs are going to be? And that could equally apply for, say, an in-house counsel when they're engaging a law firm. So part of this session as we go through it is I want to, part of it is going to be explaining the history and mindset of lawyers. And part of it is I'm going to be showing you some of the tools as I would teach them to lawyers, so that you can see for yourself, assuming that most of the people in this, watching this webinar are themselves project managers. So you could see for yourself how I would go about explaining and contextualizing and adapting some of these tools for lawyers. And so that you can appreciate also the very low baseline that oftentimes, surprisingly low baseline that sometimes lawyers are actually coming from. And that, the foundational principles are, surprising, can be surprisingly unknown is probably the best way of phrasing it for the lawyers concerned. What I like to do normally at this point is, having kind of introduced lawyers to, and I'll have taken lawyers oftentimes through some of the slides I've just shown you, is to now kind of bring some of this together and explain to them, how would they have a kickoff meeting? What are some of the key features that they'd be required to look at? And we start off with describing them. What's the objective? What are we actually trying to achieve here? What does good even look like? Is this work actually a priority right now? And these particular bullet points are very relevant in particular for in-house legal teams. Consider things like risk, effort, urgency, and degree of strategic alignment. And in particular, have we actually done this piece of work before? Harking back to that earlier issue I mentioned with mindset, where they look for something, can't find it, well, I guess I'll just recreate it. I wouldn't trust anyone to do it anyway. So asking, have we actually done it before? They might seem like a very simple little list. That list was actually, I had co-developed with some extremely senior partners across a couple of large law firms. So it's they might seem trite, but highly effective. The idea is to get lawyers to consider those big considerations, those big picture considerations, before we then jump into some of the detail about detailed strategy, stakeholder identification, budgeting, and communication. There's a particular story which I like to tell at this point. If any of you happen to have read the Checklist Manifesto by Atul Gawande, if you haven't, I highly recommend it. But it talks about the history of the checklist. And in the context, it was in the context of the story, it's originally started off in the US. Post World War II, the US Air Force was procuring a strategic bomber between Lockheed Martin and Douglas, I believe, were the two contenders. One of the planes was, I think it was Lockheed Martin one, was twice as good, flew twice as far, had twice the payload, twice as fast. It was basically the better plane in all respects, and was widely expected to win this particular final fly off between the two planes, this demonstration. So Lockheed Martin was taken off first, and about half a minute into the flight, it inexplicably just fell out of the sky, hit the ground, and killed the pilot. So they did a bit of it did a retro or into what had happened afterwards, and they discovered that not only was it that Lockheed Martin plane twice as good, but it was twice as complex. And the pilot had, this very experienced fighter test pilot, mind you, had forgot to do something simple like effectively take whatever the lane equivalent of taking the handbrake off is. So from that, they decided the concept of a pre-flight checklist was born. And if you think back to the heady days when we were allowed to travel, it's almost commonplace to expect your pilots to be looking through a pre-flight and even a post-flight checklist. So that's where it came from. And the lesson that I have for lawyers here is that in every cockpit, there'll be within each arm's reach of the pilot and co-pilot, there'll be then a checklist, a book, which lists what to do in case of any type of emergency that they could possibly simulate or imagine. And normally it's a very simple checklist. When you're at 30,000 feet and you have a plane full of people, you don't really have time to call help desk. You need a few items that are really going to move the needle quickly, and you've got to be sure they work. And the discipline of the pilots is to go through that checklist. Doesn't matter if they've been in that cockpit seat for 30 years or for a week. Doesn't matter. They go to the checklist. And that's the key word, discipline. See, because then I'll ask lawyers, okay, so knowing our profession, do we have that same discipline? Or is it in fact the opposite, where the more senior the lawyer is or partner is, the more likely they are to trust their gut and go, well, I had to do this before. I don't need to be told how to do things. I don't need checklists. It's certainly the latter. And as a profession, the legal profession certainly can lack that degree of discipline. They can be cowboys in terms of following certain procedures. It's interesting because in the actual subject matter itself, in terms of legal discipline, yes, absolutely acutely minded towards that, but process discipline on how to get there, not so much. So it's certainly just kind of an interesting insight, and it certainly that story really resonates with lawyers when I'm articulating it. Which then goes into, I sometimes will show people this little toy, and it kind of gives you a sense of, it kind of brings it to life. There's a little puzzle I picked up. It's a $15 puzzle which you can use for, it's meant for 5 to 7-year-olds, and as it turns out, legal executives. But we give them this puzzle, and we ask them to build me a pyramid. And it looks pretty much like you've got on screen, and the little pieces come out, and they're different shaped pieces, 2D pieces, and you can arrange them. I ask them, can you build me a 3D pyramid? Without any further explanation, just saying it's a very important project, and I'd like you to get started straight away, maybe in teams, and off they go. And I ask them to ask me questions. Now, some of the questions they pop up, some people ask, okay, do we have all the pieces, and is it a triangle or a pyramid, and how tall? And they'll start to ask some of these questions. Interestingly, they'll start to get very competitive. I've even seen lawyers start to build little, forts with their laptops around what they're doing so that others couldn't copy them. But what's most telling, and I've done this exercise with many thousands of lawyers, and there was actually only one team which managed to ask the questions, the correct question really quickly. It's actually from the team from Google, perhaps unsurprisingly. No one ever thinks to ask for the instructions, ever. We've got smart people here, smart people in a room. Who does anything without some degree of instructions? In legal land, it's called a precedent, an existing document. But give it the smallest challenge, they jump straight in. Like I mentioned, ready, fire, aim. They jump straight in, to heck with the instructions, and they just jump in. It's a phrase that I often say that lawyers, they're smart people. They've had certain academic rigors to even get into law school, but they overcome poor project management with intellectual horsepower. They tend to rely on it, and some of the most brilliant legal minds I've come across tend to be some of the worst project managers. Why? Because they keep everything up here, and they understand where things are going, but they're unable to articulate that to their team, let alone their clients. And it makes it very difficult to work with them, or for them to more proactively plan. Maybe they have a very good sense of what the risks might be, but for the mere mortals working with them, it's a much more stressful scenario, and we really don't want our clients in that position. So before I get into the next section, which will kind of just take you through some examples of how I'd be teaching lawyers, just wanted to, and this is very much linked to the Australian legal professional laws. So bear that in mind. I understand this is a UK audience, but it does give you a sense of some of the fact that actually I would argue that these principles of project management are actually embedded in many of the professional requirements of lawyers, and do give rise to a range of very applicable and day-to-day ethical challenges, which lawyers can find very difficult to answer. For example, should a lawyer actually undertake out-of-scope work to deliver a successful outcome? Oftentimes we see lawyers not even including work as out of scope, because the traditional model of time, hourly billing, back in even only 10, 15 years ago, the clients weren't demanding the kind of work breakdown structure or costed estimates based on phases that they'd be demanding now. They were happily just to accept, defined definition of rates and then trust the professional to get the job done. Now that's a bit different, and so they should be tracking out of scope work, but should they feel compelled to actually deliver out of scope work when they know that that's required? Another one, thinking back to the time cost quality, if they're directed, the client's like, no, actually, can you please cut a few corners? I've got a limited budget and or time frame, and I just need an answer. Can you whip something up for me quickly? That's fine, but lawyers will be equally under a degree of profession. We potentially expose themselves to professional indemnity insurance claims and liabilities. So there's a certain baseline requisite degree of quality that must be delivered. The challenge as lawyers is that oftentimes they believe that the bar for quality is always set very, very high. They almost shudder when we suggest, in terms of time cost quality, that you could somehow lower the level of quality. But as I explained to them, we're not really talking about lowering quality. What we're talking about is really lowering quantum of work. Are we talking about a one-page heads of terms, or are we talking about a 100-page contract? Both would be legally correct. It's just obviously there's a different quantum of work involved between the two. Another key issue, should clients be charging, or should clients be charged for legal project management services? Oftentimes, for example, it's actually written in various professional, at least in Australia, that we can't charge for developing up an invoice. But does that extend, the concept extend to matter management or project management? No, but are clients prepared to pay for it? Or are they only prepared to pay for when they're actually on the tools doing, black letter legal work? Notwithstanding that it absolutely obviously delivers a better outcome when the lawyers have taken the time to plan. So just as a kind of I won't go into all of them, but just kind of give you a flavour. You can read them on screen of some of the real ethical issues that arise for lawyers day to day when they're trying to implement project management. Another interesting one I might just raise before I move on, noting that the concept of watermelon reporting, where everything's it's green on the outside, but everything's actually red on the inside. And it's the most commonly reported ethical breach for project managers. The extent to which that also applies to lawyers. We'll often, we can see them in particular when they're providing their monthly invoices, what's referred to as WIP, or work in progress, which is effectively unreviewed build time. They can play a degree of flexibility in terms of, maybe it looks like we're running a bit over on the budget, but maybe if we just, don't report it or underreport it, I'm sure we can make it up in the back end next month. Arguably unethical behaviour. Does it happen? And people, to give the perception that there's the budget's been smoothed out, almost certainly. And I thought just to round out this particular section, just in terms of, if you're curious how many professional legal project managers are out there. So this is actually some recent statistics. I've written an academic paper introducing legal project management to academia. It will be shortly published. It's going to be the first peer-reviewed academic paper on legal project management actually out there. But as part of that, we did some analysis, and we're just looking at LinkedIn as a proxy, and you can start to see some of the numbers there. We've got about 400 odd in Australia, and double that in the UK, many more in the US, about 5,000 globally. But that's for people that define themselves as legal project managers. There are also a variety of related fields in the legal, and these results are filtered for the legal profession. There are a variety of other related roles. So case management, which is basically the application of project management to a litigation matter or a case. So case management, you can see there's much larger numbers there. There are quite a few pricing practitioners and pricing specialists operating in the legal sector, and a small army of people looking at process design and process improvement. Arguably, a case manager, a legal project manager, I would argue the same thing. An LPM is going to be doing large aspects of pricing, absolutely. And would an LPM do a degree of process design? Yes, they would. So it starts to give you a bit of a flavour in terms of the people, the numbers of people operating in this space, and it's certainly a growing area. In terms of just the history of LPM, the term was only first coined in around 2010. So it hasn't existed for that, really only about a decade. The first law firms to implement firm-wide legal project management training were in the US, Decet being one of the first. It took about a year or two for it to jump across to the UK. So the Magic Circle and top tier firms, the Silver Circle, have certainly been playing with LPM and have established LPM capabilities, certainly since 2012, if not arguably just a little bit earlier. It took a few more years, about 2015 or so, for it to jump across to Australia due to some of the international tie-ups between Australian law firms and in particular UK law firms. So it's a new and emergent area as a distinct profession in its own right, or discipline in its own right. So I thought I'd just quickly take you through some of the concepts here, just to give you a flavour of how the entry level some of this training can be. And I'll whip through these because I want to get onto some legal tech as well. Concepts like a work breakdown structure are oftentimes not known. So a very simple, lawyers will absolutely live in the concept of checklists and use you have to the amount of information, and a lot of legal work actually is task management and task tracking, particularly in a transactional area. So having a concept like a work breakdown structure is extremely useful for them. And I'm explaining, look, if you don't know what you're doing, who's doing it, when it's due, or has it been done, you can see how managing that is going to be incrementally more difficult. Yes, so this becomes a mechanism for them to be able to understand, effectively red flag review, how much certainty they have over their planning. We're not asking them, particularly say in the concept of litigation, to be able to plan all this from the start. Litigation is actually much more adept or suitable to more of an agile or incremental planning approach, where we have periods of, we have a window of certainty or a horizon of certainty until say the next directions hearing. We can't really plan after that because we don't know what the courts are going to say or what the other side will do. But we can plan up until then, and then we ask is, are we done? Are we settling? And then if we're not, okay, maybe, so we're not done. We can plan for the next little bit, the next sprint, if you will. Those types of modalities really apply well to some types of legal work. Other types of legal works, more transactional-based legal work, we can actually have a degree of certainty about what's being done. Your typical more Gantt chart style, waterfall approach to project management is very applicable. Speaking of which, most lawyers will not have seen a Gantt chart before. As I explained, look, it's just your work breakdown structure with a calendar attached to it. Usually for lawyers, however, as distinct from in a project context where you would expect a Gantt chart to be quite sophisticated, have hundreds, not thousands of line items, you would have a team dedicated to actually implementing and updating this on the regular. As I mentioned earlier, oftentimes it's the lawyers that are doing this themselves. So the recommendation is plan on a page. We're talking maximum 20, 30 items, because otherwise they just simply won't update it. And the risk of an out-of-date Gantt chart is, it's not only, it's misinformation, it's actually dangerous. So the recommendation is to keep it simple, plans on page. And we will often have tools such as, this one's built in Microsoft Excel. They can potentially use Microsoft Project, but frankly, I found that products like that over-engineered for their purposes, not to mention the fact that it would require a separate license, and particularly for in-house legal teams, being a cost center, they really don't get to demand specialist enterprise tools. Even in engineering organizations, oftentimes the MS Project licenses aren't extended to the legal team. So they're oftentimes they're restricted to usually the Word and Office 365, or now referred to as Microsoft 365 suite. That's what they've got access to. If they're lucky, they might have a dedicated matter management system, but the tools need to be simple. So that's why we actually are usually teaching them, things like Gantt charts in Excel. We'll introduce them oftentimes to the concept. This is a very simple introduction to how they might take a lean-based approach to understanding how to optimize their work. Oftentimes, they will have never developed up even a simple Gantt chart of the type of workflow they do, which I find incredible. You'd think that as a project delivery agent, if you were doing a type of work on the regular, week in, week out, that you would have at one point documented a template of how that work is normally done. You'd be surprised the number of times that that's never been done. So we take them through exercises of actually getting them to develop up their own their first template Gantt chart. We'll do it with post-it notes and a piece of A4 paper and get them to actually draw it up you can see the epiphanies happening when we do these exercises. And then we'll take those same post-it notes and then get them to place them on a value versus duration. So kind of pivoting from a Gantt chart into more of a lean-based assessment of the amount of value of these tasks, and talk them through how tasks which have a high duration and low value, and arguably there are tasks such as due diligence, the typical having young lawyers in a dusty basement page turning thousands of documents as part of an extensive due diligence. That no longer needs to be done by humans. That can increasingly be done by their very good artificial AI-based technologies that can really do a lot of that, or at least a first pass review of that. Or if you've got tasks which don't take long but still don't have much value, we'll have a lot of kind of administrative and registration tasks. Do they need to be done by lawyers who are an expensive and limited resource, do they need to be done by lawyers at all, or could they be comfortably outsourced to an LPO, so effectively, which is a legal BPO, an outsourced provider? Could that be done? Increasingly, we're seeing it's an emergent area, but increasingly we're seeing law firms and in-house teams becoming more comfortable outsourcing various parts of their work, both back office, administrative tasks, and increasingly some aspects of structured legal work, outsourcing that to lower cost resources in different jurisdictions. For tasks that don't have much duration and have high value, oftentimes, and this is where document automation or procedures around quality assurance will become quite important. So there's a variety of these kind of exercises are really useful for helping lawyers start to understand their own workflows and understand that it's not a homogeneous whole, that it will be broken up in discrete phases or tasks, and that some of those tasks can be optimized or delivered in different ways. Right, moving right along, and just kind of taking note of the time, because I think we're chugging along here. Other areas that we'll introduce lawyers to, the concept of estimating, both bottom-up estimating, again, building off the work breakdown structure, as well as top-down estimating, whether it's t-shirt sizing or reference class forecasting. One of the most useful tools that I've shown lawyers has been PERT, program evaluation review technique. Just the weighted average of your worst outcome, your most likely outcome, and your best outcome. This again is seen as revolutionary for many lawyers who are used to just asking for a single number, single time estimate. A good example is barristers. I'll be shortly, a couple of weeks, I'll be delivering an introduction to legal project management training session for the New South Wales Barristers Association. And they're oftentimes required to give estimates, not just cost estimates to their clients, but time estimates to the courts. And I've heard it by way of story that oftentimes judges will listen to all of the various counsel, silks or QCs will be telling them how long they think the court will take, or the particular hearing will take. And what they do is then they just simply add all of them together and come up with a much bigger number than any single silk or QC estimated, because they have such little faith in the numbers that are being put forward. So the argument is if we can, this is a data-based approach, rather than just the gut feel, trying to use a more structured approach to, and a defensible approach to understanding how long something's going to take or what the cost might be, based upon a range of factors, but looking at effectively kind of an applied version of reference class forecasting. We had similar-ish looking matters, which we think that they, the worst case was this and the best case was this, and so we've arguably landed in this range here in the middle. That's a lot more defensible than just coming up with a single number as a best guess. Sometimes I'd argue that math and lawyers is a little bit like oil and water. Sometimes they don't mix because they usually did really well in English and history and not necessarily in math. But a simple tool like even a simple mathematical equation like that is usually acceptable and very useful for the lawyers. Okay, communication. I think I've already covered some of those points, so I'll jump on. Other areas that we can show them, we've got here a simple, in terms of stakeholder management, an influence first interest matrix. This is an example of the type of challenge scenario that I'll give when I'm teaching lawyers and students. And fascinating that they, again, they'll have never come across these kind of concepts before, but absolutely are applicable. And it really highlights when you ask a group of, you can ask a group of very senior lawyers, this kind of scenario, and some of them, generally who we manage closely, there'll be a degree of agreement around that. But outside of that, there can be significant degrees of variance, even within the same organization, the same legal team, about who should be, what type of stakeholder should be managed in what type of way. And it really highlights the point that the importance of communication, and for the team to actually be a team and have a discussion about these types of issues, so that otherwise we end up with key stakeholders being treated in different ways from different members within the same team, which is could be a recipe for disaster. And on the concept of teams, again, they will, we'll introduce things like Tuckman's process of team formation. Again, the concepts they will have never come across. The important part, there's a lot of text on page. So normally the key takeaway from this one is that this can be done in a kickoff meeting, basically. When a partner, say in a private practice environment, they've got a new matter, they'll usually walk the floor, and it's basically whoever happens to be, who they like, or who's happened to make eye contact with them, and who they think kind of doesn't look too busy, they're just grabbed. All right, you're now part of a project team. At that point, they're not a team; they're a collection of individuals. And making it clear to the lawyer who's managing them, to set some very clear understandings of where they're heading, what the objectives are, and how the team's going to, how people are going to resolve differences, and how they're going to communicate with each other. Effectively a governance and communication framework. Because without that, they're going to spend a lot of time tripping over each other, potentially rework, disagreeing, agreeing to disagree, and broadly just not understanding where they're heading. There seems to be an assumption that just because people are working in the same law firm or in the same practice area, that of course they can work together. And so short shrift is often given to key concepts like team formation. Again, which we covered off in a kickoff meeting. It's a 15-minute conversation. One of the other aspects closely related to teams, and this is quite an important one, is the concept of psychological safety. The legal profession has a bad reputation in this respect. It can be quite an aggressive profession, and often, oftentimes people do not feel comfortable asking for help. It's just the very nature of the profession. It's kind of a fake it till you make it. No one, there's an expectation that even as a junior lawyer, they feel the pressure just to know everything. And God forbid they be allowed to show weakness or admit that they don't know something. So oftentimes you can have, a quite psychologically unsafe environments within a legal environment, within the legal team. And so important, some of these questions are actually quite important. Can I be judged for making a mistake? Will the team support me or undermine me? Am I able to take risks? Now, these are elements that anyone needs. Trust is an inherent part of any form of high-performing team. There are plenty of studies to confirm that, and I'm sure your own experiences will align with that as well. But we mentioned earlier, one of the kind of predispositions of the legal profession is low trust. So it's a challenge to try and create environments, which are higher trust and where you can have a sense of trust and a psychological safety. This actually does have significant impacts upon the profession. This is, we are known as the burnout profession. This is actually a cutout from the New South Wales Law Society journals from last year, talking about the actual impacts of burnout on the profession. They're not insignificant. $10 billion, and that's just in the New South Wales market. Sorry, in the Australian market, $10 billion in terms of the actual cost. You can see the churn, 40%. These are high figures. So how do we address this? Simple concept like a retro. Otherwise it can feel like it's almost too much for a junior. How does a junior lawyer possibly change the culture of a law firm that they're in? Well, concepts like retro I found are a very inoffensive and easy to implement way of ensuring psychological safety and a greater sense of team. Particularly if instead of just having a retro at the end of a project, like typical project retro, having the temerity to ask one of these halfway through a matter, particularly if it's a longer matter, a longer project. Why? So that we can actually course correct. Because otherwise we have lessons learned, but lessons learned, very even rarely recorded, let alone acted upon or reviewed actively before the next project in law firm. So why don't we just kind of take that as read and have one of these halfway through so we can come up with actionable insights and possibly course correct and change our behaviors if we need to. And so these are some of the idea of some of the questions that could potentially be asked of law firms, or of legal teams in a retro. How are we onboarding team members? Do people understand what's going on even? How are we prioritizing our work? Are we collaborating well? Are we actually communicating changes? We find that sometimes a certain legal department, or within, say, private practice, a certain practice area might have the key relationship with the client, but and then they've got other practice areas which are kind of feeding into that main piece of work. Are they a bottleneck for communication, or are they actually, and do these other practice areas feel that they've got the voice, they're hearing the voice of the client? Have we got feedback? And importantly, is everyone okay? We have in Australia something called Are You OK Day. I'm not quite sure if there's a UK equivalent. It's kind of a well-known celebrated day where it's just addressing things like workplace bullying, behaviour, depression. People ask, are you okay? And that's great. It's great that we have a focus on that one day a year, but what happens for the other 360 odd days? It's back to work. So asking as part of the project, are you okay? I think is a part of the responsibility of leadership of project team leaders to actually do this and try and drive changes in culture where appropriate. Conscious we're running up on time, so by the way, Rob, feel free to jump on in if we've got questions, otherwise I'll continue to talk. We've got one of the other areas of delegation. This just kind of provides you with a quick little summary of how I'll be teaching delegation to lawyers. Because most oftentimes how they will delegate is to simply, they'll bark, maybe this is true of other professions as well, but they will simply bark orders at someone. Maybe a brief email, here it is, get to it. Very rarely do they actually do the homework of actually explaining what good looks like, coming with examples, or even asking to then have that person, the delegatee, if you will, check, confirm how they're going to go about that work and confirm their approach. It's considering that there was that research, a piece of research done by the Project Management Institute about 4 years ago, which looked at the leading cause of project failure globally. And the leading cause of project failure was delivering the wrong thing, which I find an amazing statistic, because where's all our effort go, of course, into doing the thing? Do we take enough time to plan, or no, even though that's the single biggest risk mitigant we could on our project? And what's the surest fire way to make sure that we deliver the wrong thing? To not tell people what we want in the first place, to delegate poorly. So delegation is a huge part of law firms, of legal practice. Even as a junior lawyer, they'll be delegating to paralegals or to LPOs. So it's a skill which and it's two-way. You can, even if you're being delegated to, as I explained to lawyers, and you've got an old partner who you're a partner at a certain age and predisposition, is a bit of the old guard and is just barking orders at you, ask them to clarify. Have the courage to ask them to clarify, particularly if it's not clear. Please give me an example so that I can do this right the first time. But you can see how this is dependent on having a degree of psychological safety and trust in an appropriate culture to support the junior lawyer asking a senior lawyer partner that question. Now, Rob, we're at 9:29. How are we doing? Are there questions out there?
Yeah, we certainly received some questions, more general than really linked to a certain point in your presentation. But
yep.
If you want to continue, and then I'll ask a couple of questions in a couple of minutes, or
yeah, absolutely. I'll just if you like me to. How long would you like me to continue talking for?
It looks like the audience are still with us, so if you're happy to still share for a couple more minutes, and then we'll go into questions, that'd be great.
Very, very much so. All right, let's get into then. Okay, let's get into risk management and how I teach lawyers risk management. So here we go. We've got the ISO definition of risk. There's our standard risk matrix. No surprises there. Again, they won't have seen this. So I'll take them through example how to identify risks, the PESTLE framework. These are, in terms of legal risks, you can see in bullet points on the bottom right-hand side of the page. These are from we've taken the leading cause of professional indemnity insurance claims against lawyers. So Law Cover is a provider of PII cover for lawyers. And yeah, we looked at some, they put an annual report, and so I've just extracted some of the leading legal delivery risks associated for lawyers. Then you can read them for yourself there in terms of some of the causes of risk, or heads of risk, if you will, from a delivery perspective, as distinct from the actual project that they might be, or the legal risks associated with the project themselves. One of the most useful mechanisms that I found for teaching lawyers, and this is an example of how we really simplify this stuff. Now, are they going to have a risk register? No. Yeah, I should have mentioned at the front. Are we even going to necessarily have a project plan? No. At best, you might have a plan on a page. it's going to be real light touch, these artifacts, if at all, because trying to force compliance, and in particular artifact compliance and documented compliance, is not going to get you anywhere with your legal team. They're just simply not going to do it. So we need to come up with really highly effective, simple mechanisms, tools which they can do on the spot, and which aren't, which don't require a lot of maintenance. This is a great example. This is a simplified and sanitized version of a risk management framework which was used to manage a global multi-billion-dollar merger of certain beverage companies, and involved about 30 countries and as many major firms, including top-tier magic circle firms from around the world. This is basically the risk register. This was a key document that was used to help, not just from a risk perspective, but really choose the option, the preferred option for this merger. And you can see there, and basically what they did is they identified some of the heads of risk to the transaction. Then they had a number of different 4 primary delivery options, and they used this then to flesh out using just a simple traffic lights, to drive a degree of alignment across this very large pool of lawyers, because lawyers love to talk, they love their words, and they can get lost in the words. So this really simplified it and drove alignment across a large group of lawyers, which otherwise would have been an absolute nightmare to try and to implement. A key word of advice when you're implementing risk management, and I've seen this happen, make them stick to the traffic lights. Otherwise, they will come up with, they don't like red, they'll really want to avoid red, but they will come up with 17 different shades of orange in order to avoid red. Hold them to, I'll try and hold them to the simple color code if you can, to make it kind of fit for purpose and useful. Rob, I'm happy to jump to questions if you like.
Excellent, thank you, Peter, and thank you for sharing all the knowledge to date. There's been some lovely comments from people saying, great session, thank you for giving up your time, thank you for the excellent session. Someone's put here, Alex put some brilliant points, very succinct. I'm from an engineering project management area and took many things away from this, even within our industry. A brilliant webinar. And he says, thank you, Peter.
That's very kind, very generous.
I'll try and combine some of the questions. So Gabrielle D, Assoc have asked, how easy is it to switch from general project management in non-legal settings to become a legal project manager? How much legal knowledge do you need to have? Could you drop a non-legal expert into a legal matter?
Great question. And I can answer this with a large degree of personal experience. Even though I myself am a lawyer, I have created from scratch, from me being the legal project manager to a significant, we actually arguably, in my previous employer, we developed up the country's leading legal project management team over a course of 4 years and grew it. And not everyone in my team was a lawyer. And in fact, where I work now at PwC, not everyone in our legal transformation team are lawyers. You don't have to be a lawyer. It certainly helps if you've got if you're trying to create the function in the first place, then it probably helps for you to have a degree of legal knowledge and worked in a legal practice before, perhaps in legal operations, and just understand there, some of the unique challenges that can come from working in a partnership model, and in particular with lawyers. Part of that old mindset, they tend to only trust their own. But if you're going into an already established team or an established legal project management team, no, you don't need to be a lawyer. And I mentor many both lawyers and non-lawyers on how to get into the profession. There's a brilliant, one of the best LPM primers that I've come across. It's Legal Project Management in 1 hour for lawyers. It was published by the American Bar Association back in 2014. Brilliant short read. They lied. It takes about an hour and a half to read. It's pretty short and punchy. But it gives you a good sense of what, summarizes some of the things I've talked about today, and it gives you a good sense of what you're getting into. At the end of the day, as long as you come in with the recognize that you can't force compliance, and in particular process-heavy compliance onto the lawyers. That's probably the biggest challenge from someone coming from, say, just say, for example, an engineering background or an organization where project management is just simply part of the DNA of how they do things, where it's expected. Of course, we're going to have change control procedures and the like. Coming from that into a law firm environment can feel like there's suddenly, it's almost like the Wild West. Nothing is documented oftentimes. There might be no processes. And you've got lawyers that don't even see the value of adhering to process and can quite, frankly, kick against it. So one of the biggest skill sets, in addition to project management, that you'll probably need is a healthy dose of an understanding of change management. It comes down to the maturity of the LPM team that you're working for. There are absolutely leading law firms that have established LPM teams where everyone's drunk the Kool-Aid, then it's a lot easier. But you still, I think, need to have that degree of discernment to recognize that it's not a compliance function. We're trying to drive a degree of adoption, but a kind of a fit for purpose, or it's an abuse of the legal term, but a de minimis amount of project management to help them get the job done, to help de-stress the lawyers' lives, and to help them be much more effective and efficient, to effectively help them help themselves. But they're simply not going to listen or comply with a heavy process-driven approach to project management. As long as you can get over that hurdle and recognize that we just need, it's a very light touch approach to project management, a lot of change management, a lot of coaching, and bringing them on the journey, then there's no reason why a project manager from another industry can't transition into a legal project manager in a professional services environment.
So thank you, Peter. Great answer. And I hope that helps the collective who I've pieced their questions together. I know Peter and myself spoke at the beginning before the webinar started about travel, and we shared that we've done a bit of world travel. Peter, Casper's asked, to what extent are legal project managers constrained by different countries' jurisdictions? In other words, is there freedom to go wherever you like compared to, say, a normal project manager?
Yes, there is. It's one of the reasons I love this job. I was formerly I formerly worked in London myself. I was a lawyer in London for a Silver Circle firm, and then I got headhunted into by their global head of strategy and market and business development, and started my journey in legal operations actually in London, and advising on legal project management way back then, about a decade ago now. So it's certainly, unlike law, which is very jurisdiction specific. Absolutely, as a lawyer, and being a lawyer myself, an Australian lawyer, I can't just turn up to London and start practicing. I need to requalify. I can't even go to Canada. We're talking common law countries here with the same federated structure, same colonial history and background, ostensibly many similar approaches to the law. But even between similar jurisdictions like that, we still have to requalify. Let alone if I was to go to a civil law country like in Europe, or a Middle Eastern country with a very different approach to law again. So you absolutely, as lawyers, they can't travel. They're stuck in the jurisdiction. But project managers, on the other hand, absolutely. There's no jurisdictional bounds. The skills are readily transferable and transportable to any jurisdiction, because at the end of the day, if you're delivering a legal matter in a code-based country like France, or you're delivering a legal matter in Germany, or you're delivering it in Singapore, or you're delivering it in Abu Dhabi, or you're in Sydney here in Australia, the piece of legal advice will still be a project. It will still have an endpoint, a start point, and a deliverable. The substance of the law might be very different. The culture of how teams work together may be different. I've spent a lot of time, 3 years living in the Middle East, in Abu Dhabi, Dubai, Qatar. I spent half a year living in Malaysia, helping the Department of Public Works to implement effectively a project management capability, a PMO office. Very different team. Culture can have an impact upon how teams behave. Even taking a concept like some of you on the call may be familiar with the concept of partnering, from the construction industry in relational contracting. which originated in the US. You take that and even transplant it to Australia. Many people think Australia and US are similar. No. So there can be cultural differences in how we apply project management principles. Yes. But aside from that nuance, you can absolutely, you're not beholden to the jurisdiction in the same way that the lawyers themselves are.
Excellent. So hopefully once this is all over, we can get on the planes and travel and explore the world again, which will be amazing.
Come down and say hi. I'll welcome you with open arms. There
we go. So you just offered 150 odd people a room for the night. So if you're ever in Sydney, go and see Peter. I joke. Peter, there are some additional questions and I'm going to send them across to you after this. And if you're kind enough just to give us some answers, we'll work that into the APM website so that we can supply the answers to everyone. But I think Catherine sums this up nicely. She says, as a lawyer of 28 years, now a legal project management consultant with my own consultancy, that was very clear and helpful presentation. So thank you very much.
Oh, that's very kind of it.
I, on behalf of the APM and all the other attendees today, would like to say thank you for your time, for sharing such great information, and also taking the time to give detailed answers to the questions as well.
It's been my absolute pleasure. I'm glad that I hope that it was informative and useful. And I've got my contact details there. I'm always happy to reach out and have a conversation. There are, as a final closer, there are absolutely developments. There's a large group of legal project management professionals, including, that sounds like some on this call, in the UK. As much as in Australia. So if anyone's interested in understanding how they can better move into this profession, please reach out, and I'm more than happy to extend and connect people in my network, both in Australia and the UK. So more than welcome, always more than welcome to, or more than happy to welcome people into this emergent discipline of legal project management.
Excellent, thank you, Peter. I'm sure you're going to get plenty of LinkedIn requests after this. Thank you very much. And on behalf of APM and Peter, I'd like to say thank you to everyone who's joined us today, taking the time to join, submit questions. I can see from the comments that you've all enjoyed it. So it's great to have you on board. And I hope that we see you all at future APM webinars. And most importantly, keep well, and we'll see you soon. Bye for now.